Our next keynote will be on the state of play of the Electronic Securities Act, and that is freely translated. The actual title is eWpG. Please welcome Dr. Tobias Riehtmüller from GSK Stockmann.
Great, thank you very much for the kind introduction. Thanks for having me. So, I'm going to talk a little bit about the regulatory landscape at the moment and how eWpG, the Electronic Securities Act, fits into that. Then we'll see what triggers the actual license requirement and how you apply for a crypto securities registrar. And then we'll talk a bit about the eWpG concepts and processes that you need to apply as a registrar. So first of all, when you're thinking about setting up a digital infrastructure legally for digital securities, distribution, processing, etc., these are typically the areas that you want to consider. Securities brokerage, where you need someone who distributes the securities. Securities processing or registering in the register. Then you have the secondary market, you have payment processing, and you have the issue of custody. The eWpG only covers this area. It's only about securities processing from the supervisory law perspective. Of course, there's also a civil law perspective to this whole topic, but from the supervisory law perspective and considering your business activities, eWpG is about securities processing, registering securities in the register. So there are other types of regulatory statuses that you need for these other types of activities. And as we already discussed in the morning, new business models are developing at the moment, and everyone considers at the moment which parts of the value chain, you could say, you cover. And just here to be everyone on the same, I want everyone to be on the same page, the eWpG is about securities processing. If you want to be an intermediator, you will need an investment brokerage license under MiFID. If you want to operate a secondary market, there are other types of licenses that can apply. We get to that in a moment. Payment processing is regulated by the PSD and the German implementation of that. And custody business is also a separate license under German law. So, well, it's quite easy to distinguish intermediation and payment processing from the crypto registrar. It's not as clear with those other two types of activities. Let's look first at custody. What does custody business mean? Custody means, with regard to crypto securities, you store the keys. You have power of disposal over those securities, or, which is also a relevant activity under the custody business license, you manage securities. So you act on behalf of somebody else in order to manage rights arising from the securities. Just to keep this in mind when you're considering the crypto securities registrar license, which does not allow, in principle, you to do any of this. However, at the same time, the crypto securities registrar needs to have power of disposal over securities to a certain degree in certain situations. And we'll come to this later when we discuss the concepts and processes. So this is why the law clarifies that only keeping the register as such does not constitute a custody within the meaning of the Custody Act, which also means that you don't need an additional license as a crypto custody business or custody business in order to do so. This means, in turn, that if you don't want to apply for that license in addition, you need to keep your activity to what is necessary to operate the securities registrar. Then we have the issue of operating a secondary market. Depending on how you do it, this can be from a legal perspective either investment brokerage or an MTF, or you can even be a CSD, a Central Securities Depository, because the law in that regard is quite far-reaching. If you operate a digital infrastructure that allows trading and settlement in securities within the meaning of MiFID. And you do this in a way that you match orders within the system, then per definition you're already a CSD. And this is why the EU pilot regime for market infrastructures has now been passed by the EU legislature. We've been talked about this a bit already, and there's also going to be a panel. I think the next panel is about this. So what does this cover? It solves the problem that if you want to operate a blockchain for securities trading, you become a CSD by providing a regulatory sandbox. The sandbox is limited in scope in terms of the instruments that you can settle and trade over the infrastructure, and also in size. And there's going to be a 6-year testing period. And there are going to be 3 types of DLT market infrastructure, depending on if you want to settle against cash or if you only want to provide trading in securities. And legally, this is not organized as a separate institute license, but as exemptions from the existing regulations. Right, so and this will be applicable from March next year. And I think will give a great number of new opportunities in order to build integrated infrastructures to process crypto securities. Then looking at the instruments that are covered by the eWpG. This was also mentioned already. In the beginning, it was only bearer bonds and certain kind of fund share certificates, or they were only allowed to be managed as central securities under eWpG. We'll come to that in a minute. So bearer bonds, this means like any kind of instruments that are organized legally as a bearer bond. So it does not mean only a plain vanilla bond, but it can also be, for example, a profit participating certificate, which can bring these instruments quite near to equity investments. Stocks at the moment are not within the scope of the eWpG, but they are proposed to be included as part of the Zukunftsfinanzierungsgesetz, so we need to follow this legislative procedure. And now fund share certificates are also allowed to be organized as crypto fund share certificates. This was introduced by the Crypto FAV, the new origins on crypto fund share securities. But also keep in mind there, not every kind of fund participation can be processed through eWpG, especially shares in fund limited partnerships cannot be registered on a crypto securities register. So they need to be securities in the first place, you could say. And also the so-called sui generis security tokens are not within the scope of eWpG. Tokenisierte Vermögensanlagen, which has been the first form of security tokens that were issued in Germany before the eWpG came into place. And just to complete this overview, this is the present legal situation in that area. We have the eWpG itself. We have the Banking Act, where a new license requirement was introduced. We have the Crypto FAV, and then these have already been passed and already in force. And then we have the, let's call it the registrar ordinance, because the name is so complicated to translate, the eWpRV, which regulates the details of the activities that the registrar performs and what requirements are there. And this, so far, is still in draft form. So we're still waiting for the final act here. And for the rest of these slides, I'm assuming that this draft is going to become the law like that. Right, then the license requirement. What triggers the license requirements for the crypto securities registrar? So this has been regulated as a financial service within the meaning of the Banking Act. So in general, you need a license if you want to provide a financial service on a commercial basis. And now this new definition of crypto securities, operation of a crypto securities register has been introduced into the Banking Act by the eWpG. So there we have our first kind of insight, okay. The crypto securities registrar, who needs a license to that, is someone who operates a crypto securities register on a commercial basis. Right, so the next question is, what is a crypto securities register? Under eWpG, there are two different kinds of registers. Electronic securities registers. First kind are the central register, and the second are the crypto securities register, where the actual innovation, you could say, is taking place, so we're focusing on this. And for the crypto securities register, there is this really complicated definition that talks about shall be maintained on a tamper-proof system of record, in which data is locked in time sequence, etc., stored in a manner it cannot be tampered with. In essence, what this means, in today's technology, it is a public blockchain. This definition is only so complicated because the legislator there wanted to take a technology-neutral approach. Okay, so this leads us to the thought the crypto securities registrar is someone who operates a public blockchain. Well, but does this make sense? I mean, it's kind of the point about a public blockchain that it does not need a single operator. So one could think at that point, is this really the meaning of the law? Yes, it is. There has been quite a political discussion about if this should be allowed at all. People could lose money if the register is not functioning properly, etc. We need someone that we need to supervise. We need someone that needs to be liable if something goes wrong with the register. So the solution that was found in the legislation is, if I want to issue a crypto security, I'm free to do so. Then I need to follow all these requirements. And if I don't, then I will be liable if something goes wrong. I can appoint a registrar who does this, you could say professionally, right? So the financial services institution, the crypto securities registrar, who then operates the register for me. And then it's this entity that all the requirements apply to. And the requirements are confidentiality, integrity, authenticity of the data need to be protected, and, which is most important, the registrar needs to accurately reflect the existing legal situation at all times. And this is, well, can be quite complicated. If these requirements are not met, then the registrar will be liable for that. Okay, I also included some slides here on the application process, but I don't want to go into too much detail here because this is a standard application process for a financial services institution license in Germany. You can read it in the slides. You need initial capital, you need managing directors, you need a business plan, you need quite a lot of documentation that you need to file with BaFin. And also you need to meet the organizational requirements. Let me mention there that BaFin has now published notes on what they want to read in such an application. And at the moment, the first, I think, 4 or 5 applications have been filed with BaFin, and to my knowledge, they are considering it and are discussing with the players. Most of them are in the status of preliminary license now. Okay, then look at the eWpG concepts and processes. There are requirements there in the eWpG itself, but also in the registrar ordinance. First, a crypto securities register does not only consist in a blockchain database, right? So you cannot simply use like a standard, like an ERC20 token or something like that, and operate the securities registrar in that. You need to modify that, and you also need to add additional elements. In particular, in addition to the blockchain register, you need an off-chain database where all the GDPR-relevant data is stored. Then there are statutory provisions for the content of the register, so what kind of information has to be stored in there, who has roles and access rights to access the register, what cryptographic processes need to be in place. And a very important requirement is also everything has to take place in the right time sequence. So when there are different orders to the register, then the registrar needs to make sure that they are processed in the right time sequence. The law also said that you need to meet certain IT industry standards, you need to have a testing regime in place, and you need to provide for ongoing transparency of the register setup and operation. So you need to document certain elements of the register and publish them, including the source code and smart contracts, how the consensus mechanism works, description of that. And there needs to be a possibility for everyone basically to verify that the terms that have been published for a certain security are accurate and are the same that basically the whole security was based on. So then there are three main areas of processes that the eWpG stipulates. First is the coming into being, you could say, of a security. And this needs to be done by a publication of the terms and the actual registration of the security on chain. So the terms need to be published in a way that is defined by the law, and they need to be freely accessible on basically the website of the registrar. If there are amendments, you need kind of versions that need to be transparent there. And the registration of the security means, okay, basically you publish a statement that these terms are now used for basing a security on. And this also has to be published in the Federal Gazette and notified to BaFin. How do I become a participant of the register? And how do I transfer securities in it? There is now a statutory definition of participants in the registrar ordinance. The issuer, obviously, someone who holds a security, but also holders of other certain rights, like a pledge on a security. And if I have a contractual arrangement with the registrar. The registrar has to have in place criteria and a procedure to allow participants to the register, and these criteria need to be transparent. Now the interesting thing, if I want to transfer a security, this is done by issuing an order to the registrar. There are only certain persons who can do that. Then the registrar has to examine if this order stands, if the one is authorized to give this order, and the registrar has to process the orders in the right time sequence. This may include an identity check of the one who's authorized, but if, of course, there has already been a KYC process at the time when people were admitted to the register in the first place, then the registrar can rely on that. And if there are incorrect changes, then the registrar has the duty to correct these. So just to give this a bit more practical relevance, say the tax authorities want to put a pledge on security. Then this is an order that the tax authority issues to the registrar, and the registrar has to make sure that the pledge is put on the securities in the right time sequence. So if I'm trying at the same time to transfer the securities to, say, my wife, then the registrar has to make sure that the order is correct. And then there's the last area of processes that eWpG includes, which is access to the register and excerpts. Just to be brief here, there are various modes of access to the register, depending on the depth of information that you want to gain from the registrar. There are different levels of requirements that you need to meet. Great. Thanks for your attention. That's it for today.
Thank you.